It's called the trial of the century. For many of those involved, it seems to last that long. In the trial's final days, the prosecution and defense try to button down their cases with witnesses that are best described as, well, odd. For example, 2 Mafia hitmen, each in witness protection, testify on behalf of O.J. Simpson. I'm Roger Cossack, and this is OJ25.
Good morning, Counsel.
Good morning, Your Honor, and thank you very much. Your Honor, we asked the court to allow us to recall Deputy Philip Van Adder based on newly discovered evidence. Detective Philip Van Adder, based on newly discovered evidence that was provided to us last Friday by Mr. Hodgman of the District Attorney's Office in chambers with Your Honor. A conversation allegedly took place in a hotel room where Detective Van Adder was allegedly quoted as saying by Mr. Larry Fiato that regarding the O.J. Simpson case, we went over to Rockingham because he was a suspect. The husband is always a suspect.
Juror Lon Cryer kept copious trial notes and a personal journal during the trial, over 600 pages in all. One of his last entries was about the strange appearance in the trial of 2 Mafia hitmen, the Fiato brothers, as witnesses for the defense.
These 2 guys who were watched over by Van Adder and Lang as witnesses to another crime. Anyway, here I'm saying Phil Van Adder says O.J. Simpson was always a suspect, and at most cases, the husband is always a suspect.
The jury now is entitled to know whether or not Detective Van Adder was untruthful to this jury when he said the purpose for going over to the Rockingham estate was to make a notification to Mr. O.J. Simpson, and because of the welfare and well-being of the children, that he was a concerned grandfather and he was concerned for the children of O.J. Simpson.
All right, thank you, Mr. Shapiro.
The circumstances from the Fiato's perspective is as follows, and I'm going to quote Craig Fiato, who I think would be accurately characterized as somewhat of a salty figure, so pardon the language. This is all a bunch of bull. Like Phil Van Adder's going to lay out the prosecution's case on O.J. Simpson to Craig and Larry Fiato, who are, quote, mafioso-type people who have turned government witnesses. Agent Wax said Van Adder was sarcastic in his tone and perfectly consistent with someone who's saying, yeah, you know, they're accusing us of all these things. Sure, we went up there not to save lives. Sure, we went up there because Simpson was a suspect. And these accusations have been made against Van Adder. Now, when you put all of this in context and you remember the immortal words of Craig Fiato to Mr. Hodgman and me at the conclusion of our interview, that everybody was making, again, the language of Craig Fiato, a big deal out of stuff that was bull. What he was pissed off about, his term, was that he made a call.
Glad you qualified that.
Thank you. My mother might be watching this, so I would like at least to make a decent impression. If the Fiatos wanted to make something of the O.J. Simpson case, as Craig Fiato said, they could have done a lot better job than just to make this statement. And they're the ones who are saying this is a bunch of.
I'm going to allow the defense to present the inconsistent statements by Detective Van Adder.
Good morning. Beverly Reed O'Connell, Assistant United States Attorney on behalf of the FBI and the U.S. Attorney's Office. First, the government asked this court to consider turning off the cameras to protect the likenesses of the Fiato brothers who have assisted the federal government in investigations, testified against Italian Mafia members.
Of the more than 100,000 pages of trial memos written by court TV producers during the Simpson trial, none documented a stranger episode than the untelevised testimony of the Fiato brothers.
O.J. Simpson trial meets the Mafia. Just when we thought we might be past the twists and turns, government snitches, the type of witness typically detested by the defense bar, testify for the defense. The Fiato brothers. Both witnesses are in the federal government's witness protection program, so we are not allowed to televise their testimony. In the courtroom, Larry was affable, willing to help the parties. Craig, on the other hand, was hostile toward Cochran and argued with him from the witness stand.
So the defense is using a couple of snitches to try to chip away even more so at Detective Van Adder's reputation. Now, it's already been hit hard throughout the course of this trial, and now we've got guys who had involvement with the mob, who rolled on them, they're in witness protection, they've got their own criminal history, certainly not the most desirable characters, telling the jury that Van Adder is a liar.
The husband is always a suspect, the witnesses said, Van Adder said. But although the witnesses were called by the defense, all three of them dismissed what Van Adder said as joking around and a sarcastic comment. Together, the two brothers pieced together the bits of the alleged conversations, that Van Adder said Simpson was a suspect, and that husbands are always suspects in these kinds of crimes.
I wish I was good enough to go to a crime scene and within less than an hour be able to figure out who committed a murder. That would be great.
Apologies for the delay. Had a few legal matters to take up out of your presence. We're ready to proceed. Mr. Shapiro.
Thank you very much, Your Honor. I'd like the court to kindly ask to recall to the witness stand Los Angeles Police Department Detective Philip Van Adder. Were you asked questions on direct examination by the district attorney regarding your reasons for going from Bundy to Rockingham?
Yes.
And have you had an opportunity to review that testimony?
I know what I testified to, yes.
Did you consider him a suspect at that time?
No.
Did you have any notion at all at that time that...
I didn't know who the suspect was. Anybody could have been the suspect at that point.
Under oath, that when you went to Rockingham, Mr. Simpson was not a suspect?
There's no doubt in my mind. Mr. Simpson was no more of a suspect at that point than you were, Mr. Shapiro.
The four of us were to go to Rockingham, contact O.J. Simpson, see if we can get an initial interview from him. Mr. Simpson, myself, and my partner will be handling this investigation after we make the death notification.
In January of 1995, were you in the company of an individual known as Craig Fiato, a deputy district attorney, Dale Davidson, an individual, Larry Fiato, and Detective Tom Lang?
Yes, I was.
During that conversation, did you state that you went to the home of O.J. Simpson in the early morning hours of June the 13th, 1994, because he was a suspect?
Did I state that exactly? No, I did not.
In sum and substance, did you convey to anybody in that room that the reason you went to the O.J. Simpson residence was because he was a suspect?
Objection, Your Honor. Calls for speculation.
Overruled.
No, I did not. There was general conversation going on, If something was taken out of context or something was said in jest, I can't answer to that. I never said that O.J. Simpson was a suspect.
Did you say that of course he was a suspect? The husband is always a suspect.
Mr. Shapiro, no, I didn't say that. Anybody that has personal contact with a murder victim before they're eliminated is a potential suspect and can be a potential suspect. I wish I was good enough to go to a crime scene and within less than an hour be able to figure out who committed a murder. That would be great.
After one of my partners had retired, we worked a number of cases together. He was very conscientious, a street cop. I would call him a very good street cop, very good cop. Unfortunately, he smoked cigarettes and he died in early 2012.
During February of this year, were you up on the 18th floor with Larry Fiato?
Yes.
And did you go out on the balcony with Larry Fiato for the purpose of smoking a cigarette?
Yes.
And did you have a conversation with Larry Fiato and in that conversation discuss the O.J. Simpson case?
Larry Fiato was asking questions about a lot of things. I have not specifically discussed the O.J. Simpson case with anybody.
And did you tell Larry Fiato that you went to Rockingham because O.J. was a suspect? The husband is always a suspect on the 18th floor of the balcony while smoking a cigarette in February of this year.
Again, if something is taken out of context, I don't have a specific recollection of making that statement. I don't believe I did make that statement.
Are you saying you didn't make that statement?
May I finish my answer, please?
Please.
Yes.
Any person that has personal contact with a murder victim is a potential suspect until they're eliminated, until the investigation is completed. He may have taken something out of context. I have no recollection of making that statement. That is not a true fact. I went to the location to make a death notification and a disposition of 2 minor children.
That was Phil Van Adder. He cared about this. It wasn't just another case. And that's the way he was with every single case that I ever dealt with him.
Have you, as a result of the exposure of this case, felt that you have been falsely accused? You, as a Los Angeles Police Department officer, have been falsely accused of entering into a conspiracy to convict an innocent man, Mr. Simpson?
You bet I have. I've dedicated over 25 years of hard service to this city. And I've done a lot of work, and I've seen a lot of people murdered, innocently murdered. And I've attempted to do the best I can to come to successful conclusions on those.
Detective Van Adder, bottom line, if you thought Mr. Simpson was a suspect when you first are going from Bundy to Rockingham, number one, would you have told that to this jury?
Objection.
You bet I would have.
Detective Van Adder, when you were with the Fiatos, Detective Lang, and Mr. Davidson, did you joke around with these people?
Yes.
If somebody characterized it as a bunch of guys bull at times, would that be an accurate characterization of what took place at times during that hotel visit?
That was mainly my contact with the Fiatos would be characterized as that, yes.
Would the same apply to any conversations that you may have had with Larry Fiato on a smoking deck while you were here for the Simpson case and he was here for whatever case it was, he was a witness?
Absolutely. I had no business with him whatsoever.
I want you to name for this jury one other case where 4 lead detectives at a crime scene left to go give notification to the person who is not the next of kin.
All right, next witness.
The next call, court please, is FBI agent Michael Wax. Court please.
You solemnly swear that the testimony you may give.
Now, are you acquainted with 2 individuals by the name of Larry and Craig Fiato?
Yes, sir.
Did you have occasion to walk out on a landing on the 18th floor of this building during the middle of a conversation between Larry Fiato and Detective Phil Van Adder?
Yes, sir, I did.
What statement did you hear Detective Van Adder say to Larry Fiato?
Well, I can't give you an exact quote. It was more of a comment, something to the effect of not going up to the house to save victims, and that he was a suspect.
All right, well, let me ask you specifically if this is what you indicated in your interview on September 16th, 1995, at the DA's office. Quote, "We didn't go up there with the intention of saving lives. He was the suspect." Isn't that what you said? He said?
I said that I heard something to that effect. I also said in the statement, I do not recall the exact words.
Were you surprised that Detective Van Adder would be discussing the Simpson case with Larry Fiato?
I was somewhat surprised, yes.
Mr. Kalberg.
Thank you, Your Honor. Very briefly. Good afternoon, ladies and gentlemen, and good afternoon, Agent Wax. Agent Wax, it would not be accurate to say that you interrupted a conversation. What you interrupted was a comment being made by Mr. Van Adder. That would be accurate, would it not?
Overruled.
That's correct, yes.
In fact, the tone you heard in Mr. Van Adder's voice as he was saying the comment you heard him say was one of sarcasm, wasn't it?
Overruled. Counsel, that objection is not well taken. This is cross-examination. Proceed.
In my opinion, it was totally sarcastic, yes.
Now, sir, why did you report on September 11th, 1995, the comment that you had heard Mr. Van Adder make on some date in February of 1995?
I thought by what Mr. Fiato had told me that this information was now in the hands of the media. And I thought the media was going to make a big deal over nothing.
Anything further? No. All right. Thank you very much, sir.
Thank you.
Ladies and gentlemen, one of the things that the trial court is empowered to do is to change the order of witnesses and change who gets to present evidence at what particular time. And if you recollect, I've required the prosecution to start their rebuttal case before the defense formally rested because there were some issues that were still left open. At this time, I'm going to allow the prosecution to call a witness in rebuttal to some of the defense case that we just heard, again, out of order, but in order to use your time and our time most efficiently. All right, Ms. Clark.
People call Commander Bushy.
All right, so directing your attention then to the early morning hours of June the 13th, 1994, did you receive a phone call or speak with Detective Phillips?
Yes, I did.
And do you recall approximately when that was?
To the best of my recollection, and I'm sure that I'm pretty close, probably right around 2:30 in the morning.
And then you gave an order?
That's correct.
And what was the order?
I told him to find O.J. Simpson just as soon as humanly possible and notify O.J. Simpson of his ex-wife's death.
Why was it that you ordered them to contact Mr. Simpson as opposed to her family?
Well, the ex-husband, but probably the big thing is that we had his children there, and I was thinking a dual custody type situation, and it seemed to me to seem to reason that it would be less difficult to contact him. Not only that, but he's a prominent personality and somebody that seemed like somebody we could get a hold of right away. But once again, the children there caused that to seem like a very good and necessary thing to do.
We wanted to obviously find the next of kin. Who is that? It's O.J. Simpson.
The defense always saw detectives rushing to Rockingham as a rush to judgment to convict O.J. Simpson. But the prosecution portrayed things differently in that this was a notification of next of kin, even though O.J. Simpson and Nicole Brown Simpson had been divorced at this point for about 2 years. Still, there were children involved that the couple shared, and this is a known couple to law enforcement, a celebrity couple, if you will. So it wouldn't be that out of the ordinary for them to notify O.J. Simpson as a courtesy because of something so terrible happening to his ex-wife.
Morning, Commander Bushy.
Good morning. How are you?
Doing fine. How are you?
Good, thank you.
Did you know that Mr. Simpson was the ex-husband?
I believe that I did.
And under LAPD policy, and in notifying the next of kin, Mr. Simpson would not be the next of kin, would he?
I don't know that.
Well, Have you read your policy lately, sir?
Well, no, I haven't read it lately, but that would certainly be the most logical person to contact for those children there.
Under cross-examination by Mr. Cochran, agrees that under LAPC policy of notification that an ex-husband was not considered next of kin and that the parent should have been the next of kin that was notified. So that was a point that I made. And I believe that was one of the last things I think that did come up in the case that I actually have a note about.
I want you to name for this jury one other case where 4 lead detectives at a crime scene left to go give notification to the person who is not the next of kin.
Well, I can't.
Objection, that's argumentative.
You know, in most cases, I'm not.
Could you answer my question, please, sir, if possible?
I cannot give you a specific case.
Okay.
However, there's not been another case like this one either.
How many times in a case are we going to be able to get a police officer who comes in and will tell us about this code of silence, or these officers testify, or that internal affairs doesn't do their job?
All right, the defense may call their next witness, Mr. Cochran.
I am here to give a specific offer of proof, excuse me, Mr. Cochran, from the defense with regard to Officer Sherry Ray, who we received discovery for just this morning. The notes with which we were provided have a lot of buzzwords and inflammatory phrases that turned out not to be something that this witness could or would say that Mark Furman ever said or did. So I would like to start with an offer of proof from the defense as what they wish to call her for.
She was worked with and was a partner with on various occasions from September 1985 through about December 1988 with Detective Mark Furman. She knows and has information regarding his use of the N-word repeatedly during this period of time. She has information regarding what she calls a code, a conspiracy of silence among the officers in protecting and covering for one another. She specifically uses a term, and I'm quoting, so there'll be no mistake about that. It's time to pencil which has to do with writing reports in a misleading way where they lie and change facts around to justify probable cause or to implicate someone who's otherwise innocent.
Detective Furman, have you ever falsified a police report?
I wish to assert my Fifth Amendment privilege.
What he did was unconscionable, but hey, he did it to black people, he did it to OJ Simpson, so what the hell?
Black people have long been critics of the criminal justice system, a system that disproportionately incarcerates black and brown men and people of color. And often the police, through profiling, through planting of evidence, and all other types of tactics that people in the black community for generations have alleged, but haven't had the smoking gun proof to make stick, they felt that, you know, in this case, you now have a defendant who has the wherewithal, who has the resources to actually challenge. The OJ Simpson case becomes this golden opportunity to put the system on trial. And now you have a defendant who can fight back.
She recalls him using the N-word, but she doesn't recall any particular time that he did so. She specifically told me that he did not say, it's time to, pencil and N-word. She cannot say that Mark Furman said that because she has no recollection of him individually saying that. Sherry Ray was assigned to West LA Division for 3 years, 1985 to 1988. During that time, she's told me today that she partnered at most, and she indicated that it was a generous estimate, at most 10 times with Mark Furman. The court has allowed abundant impeachment evidence. We have Laura McKinney's testimony that he used the N-word 42 times from 1985 to 1988. We have him saying it in his own voice, the best impeachment evidence the defense could ever hope to have admitted in a trial, the court admitted. We have Natalie Singer saying there's no good end like a dead end, highly inflammatory and prejudicial to the people's case. I submit a statement of his that he made apparently back in 1987. Roderick Hodge testifying that he addressed him as an in January 1987. So we have all of these witnesses who have already extensively impeached Mark Furman on his use of the N-word. This witness adds nothing to that. We've demonstrated over and over again that no matter how many times this man used the N-word, no matter how bad a racist he is, there is no evidence that he had any opportunity to plant any evidence in this case or to falsify anything in this case or to do anything wrong in this case.
Sherry Lewis stands up here now and says that, oh, there's no way he could have planted this glove. We're going to demonstrate to this jury he had plenty of time to plant this glove. We're going to demonstrate when and exactly when he could have done it, and that he has a willingness to fabricate, and that not only could he have done it, he did it in this case. So that's just rhetoric. I'm telling you what we expect to prove to this jury. And the thing that's so relevant about this is a police officer, Judge. You know, how many times in a case are we going to be able to get a police officer who comes in and will tell us about this code of silence, or these officers test a lie, or that internal affairs doesn't do their job? There's a number of officers out there that are doing this thing over and over again. This is a police officer who is saying that. Now, I think that's very, very important in a case where we've said these things do in fact exist.
This is going on with African Americans every day. It's going on with Latinos. It's really happening to women. I mean, it was just such a malignant disrespect and disregard for African Americans, other people of color, and women. But you know, we were the only ones at the time that was really complaining about it.
Nobody in this case planted blood or any other evidence, and there's nothing to show and no evidence to show that they did. Simple as that.
The objection is sustained for these reasons. I find the argument regarding the necessity of corroboration to have no merit. The racial animus of Detective Furman was corroborated by multiple witnesses who testified to the same thing. Also, his voice is on the tape, or that is abundantly apparent. There's no factual dispute that's even plausible at this point.
I have 4 kids, 2 kids I haven't seen in a year. They ask me every week, Dad, how much longer?
Closing arguments in the People versus O.J. Simpson are just around the corner. They will not be forgotten by those who witnessed them. But before that, a moment that people have been waiting for over a year. In front of the jury, O.J. Simpson talks about Nicole and his marriage for the first time since the murders.
Mr. Simpson is present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazier, Mr. Neufeld, Mr. Allman, people represented by Ms. Clark, Mr. Darden, and Mr. Kelberg. Jury is not present. All right, one last thing that we need to discuss. Mr. Cochran, I indicated to you previously that I wanted to make certain, my understanding is that the defense is going to rest today, as is the prosecution in front of the jury, and that your client, you've discussed with your client his right to testify as a witness, and it's your choice and his agreement that the defense rests at this time without presenting his testimony. Yes.
In this regard, just 2 quick things to the court, please. We do, at the time we rest, we will move the court for a motion of acquittal on behalf of Mr. Simpson and submit that, if the court pleases. And Mr. Simpson would like to make a brief statement with regard to the purported waiver.
Your Honor, the people would object to the defendant making any statement in court other than a waiver. That is the only appropriate statement that he should be making on the record at this time.
All right, it's not before the jury at this point.
I urge the court strenuously to exercise control here, take the waiver, and do not permit, basically, allocution. That is testimony without any cross-examination. It's inappropriate. It's done very deliberately by the defense for a clear purpose. Please don't do this, Your Honor. I beg you, take the waiver and let the defendant admit that he will not testify and waive his right, but nothing further should be said on the record and in open court.
This is still America, and we can talk, we can speak. Nobody can stop us from speaking. The court asked me about Mr. Simpson. I just respectfully indicated to him that he wanted to just briefly address the court, and they can't stop him from speaking. And that's what it boils down to, Your Honor. So I think
it also boils down to the court can control the orderly process, and all I'm interested at this point, now that I've been told that the defense intends on resting and not presenting any further witnesses or any further evidence other than their proffer, that Mr. Simpson understands his right to testify as a witness, that after discussing that with his lawyers, he's making an intelligent decision not to testify.
Well, we had a whole team which had worked for weeks and months in terms of
scouring Simpson's background. We had most of his public statements, whether written, verbal, or otherwise recorded. We certainly had the advantage of knowing about the prior instances of domestic violence involving Simpson and Nicole. Probably it would have been Marcia Clark doing the cross-examination, but we never got to that point. We were prepared to go there, but they decided not to call him.
Mr. Simpson, good morning, sir.
Good morning, Your Honor. As much as I would like to address some of the misrepresentations made about myself and Nicole concerning our life together, I'm mindful of the mood and the stamina of this jury. I have confidence, a lot more it seems than Ms. Clark has, of their integrity, and that they will find, as the record stands now, that I did not, could not, and would not have committed this crime. I have 4 kids, 2 kids I haven't seen in a year. They ask me every week, Dad, how much longer?
All right.
This trial over. Thank you.
All right. Mr. Simpson, you do understand your right to testify as a witness?
Yes, I do.
All right. And you choose to rest your case at this. All right. Thank you very much, sir.
He was respectful to the court, yet was able to get in a little jab at Marcia Clark there. And even though the jury didn't hear this, we have to remember, America heard it. This trial was televised, so everyone at home saw this, that confidence that he was exuding there, saying, even though I'm not going to testify, I am very, very confident in the integrity of the men and women on the jury.
May I also ask, Your Honor, for the court to inquire of Mr. Simpson, perhaps he would allow me then the opportunity, since he would like to make these statements to the court, I would like the opportunity to examine him about them. May he take a seat in the blue chair, and we'll have a discussion?
Thank you.
Every defendant has a right to testify. Most don't. OJ Simpson did not testify, but most just waive their right. And instead of just saying, no, he understands that he has a right to testify and that he's not going to, OJ Simpson kind of got up and started to make a little bit of a speech, which is not really allowed because it's kind of like testifying without being cross-examined. It was another element in the whole kind of circus atmosphere and the loose control of the courtroom.
Let the record reflect that we have now been rejoined by all members of our jury panel. Good morning, ladies and gentlemen. All right, Mr. Cochran, on behalf of the defense, do you have any further testimony or evidence to present?
Good morning, Your Honor. Good morning, ladies and gentlemen. I'm very pleased to say that we have no further testimony to present at this time, and as difficult as it is, the defense does rest at this point. Thank you.
Ms. Clark, on behalf of the people?
Yes, thank you, Your Honor. Good morning, ladies and gentlemen. We ask the court to receive all of the people's exhibits, and the people rest.
All right. On receipt of the exhibits from both sides having now rested. Ladies and gentlemen, as you heard, the counsel for both the prosecution and defense have rested their case. There will be no further testimony or evidence presented to you. You have heard all the evidence, and it is now my duty to instruct you on the law that applies to this case. After I conclude reading these instructions to you, we will commence with the argument of counsel. The law requires that I read these instructions to you here in open court. Please listen carefully. It is also my personal policy that you will have these instructions in their written form in the jury room to refer to during the course of your deliberations. You must base your decision on the facts and the law. You have 2 duties to perform. First, you must determine the facts from the evidence received in the trial and not from any other source. Second, you must apply the law that I state to you to the facts as you determine them, and in this way arrive at your verdict and any finding you were instructed to include with your verdict. As I indicated to you, we will stand in recess until Tuesday morning, September the 26th, to begin at 9 o'clock with the arguments of the attorneys. It's an interesting date because if you'll recollect, those of you who came to us in the first batch of jury selection. We actually started jury selection on September the 26th, 1994, and I see some people recollect that date.
People put on their case, the defense put on their case, and I assert that the defense case is a bunch of smoke and mirrors. It's all about distracting you from the real evidence in this case.
We've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. My apologies to you for the late start, but we had some matters we had to get out of the way before we actually start with the arguments of the attorneys. However, we are now ready to commence. We are at that stage where the attorneys will have the opportunity to argue to you. And I should let you know that previously I had contemplated placing a time limit on the lawyers in their argument. Some of the factors that I considered in whether or not I should place a time limit on them was the quantity of the evidence that was produced, the conflicts in the testimony, and the complexity of the issues that you'll have to resolve. And after considering the length of the case and the nature of the evidence, I have decided not to place a time limit on the argument of the attorneys.
In most cases, 21 hours of closing arguments would be ridiculous. But this is a case unlike any other. You are talking about months and months and months of testimony and evidence. So lawyers are going to take their time to try to put it all together and make it into a nice, clean package. The problem is, if you're a prosecutor, you've got the burden. You've got to prove it beyond any and all reasonable doubt, and it's got to be digestible. But 21 hours might be a bit too much to bite into.
If I could give you any advice as jurors, any advice at all, I would say to you, use your common sense. When you get all of this evidence and go into the jury room, and after you pick a foreperson, take that common sense that God gave you, take the evidence that the prosecution gave you and the defense evidence. Go into that jury room, sit down, spread it out, using that common sense to ask yourself a question. What does the evidence show? These killings were rage killings. Rage. I mean, you have to say to yourself, well, who in the past has ever raised a hand to this woman? And that's what the 911 operator heard. She told you on the witness stand that she heard that. She heard the sound, the noise of someone being beaten, and she put that out on the radio. Recall that? She put it out on the radio that there was a woman being beaten at 360 North Rockingham.
911 emergency. Hello?
I heard a female screaming, and then I heard what I thought was a slap. I went back and updated it as a female being beaten at the location.
Now, they may say that this isn't important evidence. I say they're wrong. This relationship between this man and Nicole, you know, it's like a time bomb ticking away. Just a matter of time. Just a matter of time before something really bad happened. Let me say this to you. We submit to you that the hand that left that imprint 5 years ago is the same hand that cut that same throat, that same neck on June 12, 1994. It was the defendant. It was the defendant then, it's the defendant now. Now, you may see these as letters of apology. We say these are letters of manipulation. What is he really attempting to accomplish here? You'll have the original letters in the jury room. In the beginning, he expresses to her how sorry he is. Actually, says he was wrong for hurting her and that there's no excuse for what he did. And then he goes on to write something I think is very, very important here. Dwight said he's thinking and trying to realize how he got so crazy. He had such emotional feelings towards her that were as high as any he'd ever felt. And it must be because of those feelings that he reacted so emotionally. With all of that emotion running in him, he says he didn't react too well.
He kind of jokingly just said, you know, to be honest, Ship, that's what he called me, Ship. He said, I've had some dreams of killing her.
Did he say how many dreams he'd had of killing her?
No, he did not.
Did he say it was more than one?
He just said dreams, plural.
He'd thrown Nicole and Denise out of his house one night. Remember that night that Denise said to him, OJ, you take Nicole for granted. And he blew up. Remember, he blew up and he said, hey, I do everything for her. And he became enraged back then, and he picked Nicole up and he threw her against the wall, and he threw her out the house, and he threw Denise out the house, and he threw all her clothes downstairs and out the house too. Remember that testimony?
Grabbed Nicole, told her to get out of his house, wanted us all out of his house. Picked her up, threw her against a wall. Picked her up, threw her out of the house. She ended up on her. She ended up falling. She ended up on her elbows and on her butt.
After you're divorced and after you break up with someone, you don't usually keep the pictures out, right? I mean, you don't. But do you throw them underneath the bed? You put them in a box, or you get rid of them altogether? That's what you do. Is that the item, Detective? Is that what you found beneath the defendant's bed?
Yes, sir, it is.
Has he threatened you in any way, or is he just harassing you? You're going to hear him in a minute. He's about to get in again. Okay, just stay on the line. I don't want to stay on the line. My kids are upstairs sleeping, and I don't want anything to happen.
He is trying to get over her, but he can't. He can't get over her. He can't get beyond this. On the one hand, he throws his picture underneath the bed. And on the one hand, she is out of sight, and he hopes out of mind. But on the other hand, she's just beneath the bed, where he has access to it, where he can grab it. The people put on their case, the defense put on their case, and I assert that the defense case is a bunch of smoke and mirrors. It's all about distracting you from the real evidence in this case. So imagine the smoke. Find your way through the smoke. And if you happen to run into a couple of defense attorneys along the way, just ask them to politely step aside and let you find your way through the smoke, because the smoke isn't over, okay? The smoke's about to get heavier because they're about to talk to you. Let's use your common sense.
The closing arguments of the People versus O.J. Simpson are not like what you see on TV courtroom dramas, where each side summarizes their case in a few minutes. In the Simpson trial, closing arguments take nearly 20 hours over a 4-day period. You haven't heard the half of it.
It just doesn't fit. If it doesn't fit, you must acquit.
I'm Roger Cossack, and this is OJ25.